Good afternoon, Mr. Imua. Welcome, everyone. Thank you so much for coming. We are very delighted to have you all here. This is ESQ Law Practical Lawyers Academy webinar series. My name is Tosi Sholanke. I am the Administrator and Head of Training at ESQ Trainings Limited. At ESQ Trainings Limited, our mission is to expand the frontiers of continuous professional learning. We achieve this by providing the highest quality accredited professional education in a variety of formats for lawyers, for accountants, tax experts, oil and gas experts, and other professionals generally. We are also committed to the development of a robust and easily accessible, comprehensive source of practical information and continuous legal education and professional development for lawyers and other professionals. We offer courses and trainings across various areas of practice, which we have categorized into academies. For instance, we have the Litigation and Other Dispute Resolution Academy, we have the Intellectual Property Law Academy, we have the Energy, Oil and Gas Academy, Corporate Law Academy, Tax Academy, Construction and Capital Market Academy, among many other academies. So we have tagged this webinar series, the Launch Hour webinar series. I are slated to hold at 1 p.m. during lunch breaks, and they will hold 3 times every week. So they hold Mondays, Wednesdays, and Fridays. However, in order to accommodate our Muslim participants, our Friday webinars will hold at 11 a.m., not at 1 p.m. So after every session, we will provide the resources in easily accessible format for everyone who is interested. So as a training academy, currently we are taking registration for our training on power. We have a training on power which is slated to commence on the 16th of February 2021. It's a 12-week virtual distance learning course, and it's titled The Dynamics of Power Contracts, Regulation, Contract Negotiation, Documentation, and Project Financing. And anyone who is interested in the energy, oil, and gas industry, trust me, you don't want to miss it. So you can get more information by sending me a mail at o.sholanke@esqlaw.com. So the focus of today's webinar is managing tax disputes in cross-border business operations. So today we'll be learning about the different means of managing double tax disputes arising from cross-border operations. Lineup of experts will reflect on comparison of the different ways of dispute resolution. You consider from the domestic law point of view, the international law point of view, double tax treaty, and then they will also review the advantages and disadvantages of the different means of dispute resolution. They will look at the understanding context, background, and interrelationship between the different means of dispute resolution. They also consider the interpretation of dispute resolution under the AFCTA Agreements and apprehend the trends and challenges of dispute resolution under double tax treaties. So today, we have the rare privilege of networking and connecting with our panelists on the work they do on these issues every day. So if you have a question while the program is going on, while the webinar is going on, you can type in the chat box. You can type your questions in the chat box, or you can raise your hand. So at this point, I am delighted to introduce to everyone here today, the participants. The moderator of today's webinar is also the chair, is Mr. Theophilus Emuwa. Mr. Emuwa is a founding partner at ALEX. He heads the firm's taxation and corporate commercial practice group. He's a legal professional with experience that spans over 3 decades. And interestingly, he's also a qualified mechanical engineer. So, wow. Mr. Emuwa, over to you.
Thank you, Tosin. Good afternoon to everyone. I'm expecting that we'll have interesting conversations this afternoon. We have 4 presenters. There's Ms. Igonikon White. There's Mr. Folajimi Akinla. There's Mr. Kemade Ajibola. And there's Mr. Ihebie. To start off with presentations, I will ask Mr. Ajibola to give us his thoughts on the topic. We have an hour for everything, including questions and answers. So if you can work with something like 10 minutes, because it's already 1:15, then it'll give us enough time to get to question and answers. So, Mr. Ajibola, over to you.
Thank you very much, Mr. Moa. There is some benefit in being asked to go first, because it means perhaps you are the first person that will be able to go over a little bit, and then everybody else is asked to make sure that they adhere to the time you have left them. The detriment, of course, is that those behind you have the opportunity to mark your script, and perhaps that would be helpful. They will supplant and provide information that I may not have provided. Going into it quickly, the topic, I think, evokes a very wide scope of areas of concern. What I have not done to assume that everybody on the platform today is a lawyer, I've also not assumed any level of knowledge or practical involvement. So I've tried to put something together which sets a general tone. I will start from the end and then come back, because I think if we are looking at managing tax disputes in cross-border business operations, and you look at the specific Nigerian situation, whilst a lot of this has to do with international related DTTs, tax treaties, tax agreements, if you may, we will come back to a conclusion which perhaps spells out a role for the domestic jurisdiction and the domestic avenues for dispute resolution. So basically, the idea is that tax disputes arise from decisions of tax authorities, be they local government, state, or even at the local government level. Specifically in Nigeria, domestic jurisdiction is given by the Constitution to the Federal High Court and by statute to the Tax Appeal Tribunal under the FIRS Establishment Act. But I dare say that jurisdiction for tax dispute resolution may also arise in administrative procedures that are available with the tax authorities and also with revenue courts that local governments may structure. Jurisdiction is administered both at federal and state levels, and usually is determined by whether the taxpayer is a corporate body or an individual in terms of how taxes are administered. And then again, if it's an individual, there is focus on their place of residence. A little note here, when I first had my initial discussion on this topic, and I looked at it as being cross-border tax dispute resolution, one of my comments was that coming back home or coming back to the domestic jurisdiction, there is perhaps a lot more to do with cross-border tax disputes arising from disputes between states in Nigeria and disputes relating to individuals who live perhaps in struggling border communities and the issues of payment of personal income tax. I've had to deal with a number of those in my time, but maybe that's not the strict focus of what we want to talk about today. But it's interesting to note that when you talk about cross-border tax disputes, we also need to look at across state borders within Nigeria. Going back to jurisdiction, the Federal High Court under Section 251B of 1999 Constitution, which states that notwithstanding anything to the contrary, the Federal High Court shall be conferred with jurisdiction to the exclusion of any other court, which is always the important part, in civil causes and matters connected with or pertaining to the taxation of companies and other bodies carrying on business in Nigeria and persons subject to federal taxation. So essentially, that's the premise for the jurisdiction of the Federal High Court. Basically, tax disputes relating to the revenue of the government of the Federation or that which is connected to companies or persons carrying on business within Nigeria. So an action may be commenced at the Federal High Court in first instance but also the Tax Appeal Tribunal by creation of statutes, Section 59 of the Federal Inland Revenue Establishment Act creates the tribunal, and the first schedule lists the list of acts that the tribunal has jurisdiction over. And this is also restated in paragraph 11 of the fifth schedule of the FIRS Establishment Act. Generally, when we are looking at issues of jurisdiction related to Tax Appeal Tribunal, people ask question, which zone? There's only one tribunal, and the prescription as to what zone commence your dispute is that the appeal must emanate from the zone in which the district or location where the local tax authority that issues the assessment took the action or made the decision against which you are complaining. If we look at the case of British American Tobacco Market in Nigeria and the FIRS 2013, also Nigerian Jeep Exploration and FIRS, where the TAT espoused basically that you should look at the geographical root of the complaint comprised in the appeal. You should look at which office of the taxman issued assessment or took the action or made the decision against what you are appealing. Also look at the district of the tax authorities in charge of the taxpayer's matter. There is obviously a process that is laid out for commencing disputes within the Tax Appeal Tribunal framework. Pretty straightforward, I would say, so I will not go into that. Then oftentimes we pitch the jurisdiction of the Federal High Court against that of the Tax Appeal Tribunal. And the issue is where it says Federal High Court shall have jurisdiction to the exclusion of any other court. I think the conclusion for most practitioners now is that without a finding that the court, the word court within the meaning of the Constitution is applicable to the Tax Appeal Tribunal, it cannot be said that the TAT's jurisdiction is precluded or excluded by the exclusive jurisdiction given to the Federal High Court as contained in the Constitution. And refer us to the case of the FIRS and General Telecom 2013. Now going to cross-border international dispute resolution processes, which mainly are drawn from or are drawn by virtue of our participation under double taxation agreements. Section 38(1) of PITA states that where the government of the Federation of the Federal Republic of Nigeria has entered into agreement with the government of any country outside of Nigeria with a view to affording relief from double taxation in relation to tax imposed under the provision of that act, any tax of a similar character imposed by the laws of that country, that is expedient that that agreement have effect, and that agreement shall have effect on ratification by the National Assembly. So that's the basis on which a lot of these DTTs or DTAs are grounded. Same with the provision coming from Section 12 of the Constitution, which says National Assembly must ratify into law or enact into law any of the treaties that Nigeria accedes to. Presently, I think we have about 19 double taxation agreements. I think the FIRS website lists less than this, but that is probably because they list the ones that have been ratified, and there are about some 5 or so going through ratification. Nigeria has adopted the model under the OECD and the UN Model Convention for a lot of the DTTs. So if you look at the sample models there and look at what we have under these DTTs, it's pretty much the prescription within there. So we come to the mutual agreement procedure. Well, the mutual agreement procedure basically is a dispute resolution mechanism designed to resolve international tax disputes that arise from inconsistent interpretations of provisions that are contained in the DTAs or the DTTs, which may result in double taxation for taxpayers, which is what we're trying to avoid in terms of managing cross-border operations. So coming from the BEPS Action 14, which sought to improve the resolution of tax disputes, even though many tax treaties have some provision of the other relating to tax dispute resolution, the idea was that we should have a sort of uniform that led to the Bilateral Convention implementation of tax treaty measures, which basically is an avenue for you not to have to reinvent the wheel when it comes to review and amendment of tax treaties with other countries. Once you adopt the provisions within that and you submit your position, effectively it signifies to partners on the other side of the tax treaties what position you've taken, and then if they have a similar position, that means there's a married or there's an alignment, and then you can hit any areas where there are differences. Nigeria's DTAs, they contain MAP provisions already that enable taxpayers and competent authorities, CAs, and then those in the jurisdictions for which Nigeria have treaty agreements. The MLI, the Multilateral Convention on Implementation of Tax Treaties, was signed by Nigeria in 2017. And subsequent to that, I think we submitted our list of treaties, 19 in all. Basically, pursuant to that, pursuant to the powers of the FIRS under Section 8.1 of the Establishment Act, the FIRS has published guidelines in Nigeria now, and a CA, a competent authority, is already named. The Director of Tax Policy, Mr. Matthew Bonjubola, is named as being the coordinator. So effectively, it's a process that is ongoing that the FIRS has put in place. That process is detailed. Perhaps I should not go into too much of that detail, maybe as we speak along, but it talks of the scope of the dispute that can be submitted under the MAP procedure. Basically, taxpayers resident in Nigeria or their related parties, including those with which you can establish permanent establishment in a treaty country, which make transfer pricing adjustments or adjustment to price and goods or services transferred to or from related party. Basically, people with dual resident status, which may lead to a person being taxed in two places, what profits are attributed to a Nigerian permanent establishment, withholdings, if that happens beyond what each DTA specifies should be applicable. And then maybe uncertainties on the interpretation of a lot of these DTAs, DTTs. The position released by the FIRS talks about who may apply. It gives a detail for the process to be engaged for the mutual agreement procedure. It talks about the conditions under which the MAP can be engaged, also strict specifications. And then we come to the nature of the MAP when we talk about the role of the taxpayer, basically because it's an agreement or a process between two countries. It's more or less a sovereign process, which is carried out on behalf of the taxpayer who has submitted a case for application. So the taxpayer himself is not really involved in the process directly. It's a government-to-government process, but once the request has been accepted, the taxpayer has some responsibilities to ensure that they supply their Nigerian authority with all the initial documentation or evidence that is requested on time and diligently, because that is what will be used to present the case. Once the two countries that are engaged in the process reach some sort of agreement, there's the duty to notify the taxpayer of what is being proposed, and the taxpayer may agree or may disagree. So the process somewhat is not binding, even if the taxpayer is the one who instigates the process. So basically, the idea is that the request for MAP will not affect your rights to your domestic remedies, basically your rights to remedies to court or perhaps the tribunal, as far as Nigeria is concerned. Where the taxpayer is not satisfied with the outcome, he may seek legal remedy outside of the of the MAP process. However, if the decision is accepted, it becomes final and binding. But then, of course, you have to move to how to implement the decision once the decision is accepted. It's noteworthy that either the authority, the country authority, or the taxpayer can terminate the process at any time before an agreement is reached. The authority may terminate MAP for failure of the taxpayer to provide sufficient information or lack of diligence, or for any other reason deemed by the authority, which is a bit omnibus, a bit wide, but it just shows the laxity within the process. And if the taxpayer decides to terminate the process, he puts it in writing to the chairman of the FIRS, and that ends the process. Then, of course, there are issues with confidentiality, also contained in the FIRS's position that has been published, the guidelines, which states that all information obtained are protected by confidentiality provisions in Nigerian laws, and also provisions applicable in the tax treaties. So the idea is that a MAP decision binding on both the competent authorities and would need to be implemented irrespective of domestic time limits, unless the mutual agreement that implements arbitration decision itself is not accepted. Otherwise, that would be the position. I've asked a question, maybe to myself or maybe something for us to ponder on, that if the MAP agreement is not binding on the taxpayer because it's really not a party to the process, but it's binding on the CA. So if the CA accepts it as binding, and the taxpayer refuses to accept or implement after the agreement has been reached, what would the legal recourse be between the CAs or a counterparty in the other country of the foreign CA? Something for us to ponder over. It's important to note that the MAP process requires the cooperation of both tax authorities. The MAP process effectively fails if tax authorities are not able to negotiate due to disagreements on the interpretations of treaties or domestic tax rules cannot be agreed. Which then brings us to the issue of whether arbitration has a place. And I think that's something we'll be touching on and discussing a bit in detail today. Well, the position, as far as I'm concerned, under Nigerian law, looking at a few of the cases, is that domestic private party arbitration or commercial arbitration of tax disputes have been held by Nigerian courts to be non-arbitrable. The Court of Appeal in SNEPCO and the FIRS case, upholding the decision of Federal High Court that disputes over company taxation are exclusive to the Federal High Court and thus non-arbitrable as they pertain to the revenue accruing to the sovereign government, and they relate to the revenue of the Federation. Thus, anything that falls under that is under the exclusive jurisdiction of the Federal High Court. Therefore, if an arbitral tribunal sits on a tax dispute or an award comes from a tribunal which relates to tax, it will be unenforceable for conflicting with the express provisions of the Constitution. Another case to look at is Statoil and NNPC, where the Court of Appeal again held that once parties have agreed to arbitrate their disputes, not to interfere, even where it relates to tax issues. But I think the way we can marry these two cases is to hold a view that where parties have agreed to arbitration on matters that relate to commercial dealings between them, but those matters have an effect on tax liabilities arising from those commercial dealings, it will be arbitrable. However, tax assessments cannot be arbitrated, and taxpayers cannot arbitrate with tax authorities. Therefore, an arbitral award between parties, even if it purports to determine tax liabilities, cannot bind the tax authority effectively. So you can arbitrate on commercial transactions between you, where at the end of that determination, it affects someone's tax liability positively or negatively. But you cannot determine an assessment that will be placed by the FIRS on you by arbitration. Generally, the MAP process itself allows some countries to adopt the use of arbitration, and some countries have indeed decided to include the mandatory arbitration mechanism within their MAP process. When Nigeria adopted and deposited the MLI, it opted not to include the provisions of Action 14 of BEPS and not introduce the mandatory binding arbitration provision. A lot of our colleagues have argued that arbitration should be introduced and that there is some benefit to be derived from allowing the process to have a dovetailing. Where MAP fails, let's have access to arbitration. But let me stop here because I think I've moved into perhaps one of the meaty areas of our discussion, which some of us will also want to comment on. And then I can add my specific comments on the issue of the desirability of arbitration under the MAP process, or the applicability within Nigeria, and how we can adopt arbitration as a means of supporting the MAP process or otherwise. Thank you.
Thank you, Mr. Ajibola, for that illuminating introduction. I will now ask Mr. Akinla to give us his presentation. I think what will then happen is we'll take questions and answers at the end of all the presentations, so that way we don't lose too much time.
Yes, thank you very much, Mr. Moa. Thanks, and thank you, Mr. Ajibola, for setting the tone for today's topic. You've touched on many of the areas I touched on. So without much ado, I'll share my screen, and I think we can proceed. Can we see my screen, please?
Yes.
Okay, great.
Yes.
Okay. Okay, so I mean, I'll touch briefly on a word on double tax treaties, the mutual agreement procedure, other supplementary dispute resolution mechanisms under double tax treaties, the trends that we've seen in the most recent times, challenges with a special focus on Nigeria, then I'll conclude. Again, the topic is trends and challenges of dispute resolution under double tax treaties. So, I mean, again, like Mr. Ajibola, I did not make any assumptions as to the expertise of persons joining the call. So I'll break things down a little bit. So what really is a double tax treaty? A double tax treaty is an agreement between two countries or states to allocate taxing rights. So what do we mean by allocating taxing rights? I can give a very small example. So let's assume there is a company in Nigeria carrying on business in Nigeria, registered in Nigeria, set up in Nigeria. Because of our laws, the company would be taxable wholly in Nigeria and all its profits. Now let's assume that same company wins a contract in South Africa. That company is expected to market, advertise, set up an office, set up shop in South Africa, service its customers, meet suppliers, etc., and sell. And that company begins to carry on a trade in South Africa. Now, what's the implication of this? The implication is that Nigeria, because of our laws, can tax that company on its worldwide income or profits. South Africa too has a claim or a say in the taxing of those profits that arise from South Africa. So what double tax treaties would do is to allocate taxing rights to say, oh, country A is responsible or should tax this particular income. Country B, in this case, South Africa too can tax, but what it can tax is restricted to the profits arising from its jurisdiction. So that's basically what tax treaties do. They also answer questions of residence, place of permanent establishment, etc. Now, I must mention that double tax treaties do not set tax rates. What they do is principally allocate taxing rights. However, there are one or two instances where a double tax treaty would introduce a rate, but those rates would come only after the right to tax has been allocated. An example would be Article 8 of double tax treaties. So why? Again, from my example, one of the main reasons why we have double tax treaties is to prevent double taxation. So you don't have a situation where Nigeria would tax, in my example, and again, South Africa would tax on the same income. Another reason why we have double tax treaties is to prevent double non-taxation. And I'll speak more on this subsequently, because you have a situation where an income, in our example again, an income is exempt in Nigeria, and also South Africa cannot tax it. In that case, the company has enjoyed what we call non-taxation, which is not right by international law standards. Double tax treaties too are necessary. They're a necessary tool for international trade and investment because they make business certain. Now, how do we have double tax treaties? Basically, double tax treaties are negotiated or agreed between two countries. And as Mr. Ajibola said, there's a model. There are two main models most countries use. The OECD model and the UN model. I think the most recent models were issued in 2017. Nigeria largely subscribes to the OECD model. States can, so the models are like templates where states or countries can adopt, and where countries refuse to adopt the exact wordings in a model treaty, they reserve their rights, which is why we have that as reservations. Now, treaties are also accompanied by something called commentaries. So a commentary really is an explanatory note to each article in a treaty. For the purpose of the double tax treaties we are familiar with, there are about 28, 29 articles. Now, each article has an extensive commentary that helps, guides, and expands the meaning of the words in the articles. So treaties, where a country does not disagree with what is contained in a commentary, it makes observations. How are treaties interpreted? Again, we have to rely extensively on commentaries in interpreting treaties. Vienna Convention, which says treaties must be interpreted in good faith, specifically sections 30, articles 30 to 33. And then there's also supremacy of the treaty. Supremacy of the treaty does not mean treaty is greater than any law in Nigeria, but it means a treaty has an international flavor, given that Nigeria has signed up to be part of something, a document that defends or protects its international relations. So Nigeria is bound to apply double tax treaties. The primary mechanism for interpreting or for resolving disputes under double tax treaties is the MAP, the Mutual Agreement Procedure. Basically, as said by the previous writer or speaker, these are discussions between competent authorities in two contracting states. So, for example, in the earlier example I gave, you would have FIRS, which is a competent authority in Nigeria, represented by an individual, and the representative of South Africa Revenue Service, SARS. These are the competent authorities of the states, and they discuss with the aim of resolving disputes arising from double tax treaties or taxation not in accordance with double tax treaties. So basically what I've tried to do is break down the steps in a MAP process. So in the MAP process, a taxpayer who is aggrieved or who anticipates that he will suffer taxation not in accordance with the treaty presents a case to either tax authority in Nigeria or South Africa, or both of them, using my example. Now I'll come back to either or both subsequently. Usually treaties would fix a time limit within which the taxpayer can complain. Now after that, when the competent authority receives the complaint, it checks to see if it can resolve the dispute by itself without engaging the other country. When it can do that, then the dispute is resolved. However, where that's not possible, it reaches out to the competent authority of the other country. And this is where both FIRS and SARS, SARS discuss with the aim to resolving double tax disputes. Now, both states by the convention have a two-year period to endeavor to resolve the disputes. Now, I use the word endeavor there because it's the wording of the treaty itself. And there's some text behind, there's some literature behind the word endeavor, which we'll touch on subsequently. Now, when a dispute cannot be resolved in 2 years, the states would refer the dispute or any resolved issue arising from disputes to arbitration. There's also a bit on arbitration. Now, what other mechanisms do we have under double tax treaty? We have supplementary tools. So we have the advanced pricing agreements. So APAs are more forward-looking. If we compare with MAP, the MAP process, usually you see a dispute ahead. So the dispute is already brewing before you engage the MAP. Whereas with the APA, there need not be any disputes. You go to the tax authority and agree in advance, maybe 3, 5, 7 years of what your tax liabilities would be or your tax exposure would be. So it's forward-looking, it's binding in the sense that the taxpayer goes and says, oh, based on this criteria, I believe my tax liability should be this, or my tax exposure should be this. So it's binding. So the tax authority, if he agrees, would hold the taxpayer to his commitment in that regard. Now, APAs can stand alone. They are standalone instruments. They can be used complementary with or complementary to a MAP procedure. The other thing we've seen under double tax treaties is mediation, but this is usually related to single or unilateral cases where you have one country as opposed to cross-border resolution of disputes. It's non-binding in nature, and with mediation you may not necessarily get a judgment. What you will get is the mediators highlighting the strengths and weaknesses of the cases of both countries. The final mechanism is factual determination. Now, this usually applies where there are contentious issues or facts, and then you need an expert to decipher what the exact facts would be. Again, this can be a standalone process. This can be used in complementary to a litigation process or an MAP process. So what are the trends that we've seen? In 2013, the OECD started a project, a base erosion and profit shifting project. And this was completed in 2015. Now, the reason or the rationale for this project was to overhaul the international tax laws and rules and principles generally globally. Now, if we think back, the models that we've used up until now, they were first introduced in the early 20th century. So you had treaties from 1940-something, 1970, 1980. So those were the treaties we had. Now, if we go back to my example, we see that there's a company set up in Nigeria that goes to South Africa to set up to carry on business. But with the advent of economic change in business models, this aided by e-commerce, the internet, we find out that companies can set up globally anywhere in the world without having to set foot there. A classic example is Airbnb. So you have Airbnb, a company that is set up in America or somewhere offshore. It's arguably the biggest real estate company because it has operations in almost all countries in the world. So because the current tax laws do not have the provisions or do not have the framework to capture such transactions that have been driven by e-commerce, BEPS, the OECD thought to introduce BEPS project. So one of the outcomes of BEPS was to amend Article 25, introduce Action 14 on making dispute resolution mechanisms more effective, introducing exchange of information rules, etc. So in essence, the BEPS project was a reaction to the way business models changed as a result of the internet and e-commerce. So what are these changes? What are these trends? So we see clearly arbitration. One of the recommendations issued by OECD as a fallout of BEPS was that states should introduce a mandatory binding arbitration in their double tax treaties as a complement to the MAP process. So before, again, I go back. So I've used the word endeavor before. Endeavor there, many states took it to mean that they were not bound to settle disputes, right? It was enough, it was sufficient for them to just try to use their best endeavors. But that wasn't really solving problems. So they OECD thought, okay, let's introduce arbitration, which will be binding. And because of its binding nature, it is hoped that many tax disputes will be resolved one way or the other. There was also a recommendation as a fallout of BEPS, where taxpayers can notify either or both states where they think they will suffer double tax. Now, this is a new introduction. What used to happen before was a taxpayer was expected to notify the states in which it was resident. So let's go back to my example. If the Nigerian company in our example suffered or feared double taxation, what it was bound to do under the old laws was to approach FIRS to initiate a MAP process. But then because of things like bias or things of or barriers to that MAP process, OECD thought, okay, let's not hinder taxpayers. Let them have the right to escalate to even the other tax authorities. So in our case, if the Nigerian company was afraid of double taxation, it could approach South Africa to initiate the MAP process. Another thing we've seen recently is a rise in transfer pricing disputes. And transfer pricing dispute is a fallout of what I said about business models changing. When we consider things that even happen in-house or at home in Nigeria, I was reading papers a couple of weeks ago, and it was reported that the FRS had set up 35 new units to track illicit financial flows. And that's a direct response to what FRS believes is a loss on its tax revenue through transfer pricing. So these are things that we've seen in trends. Closely related to that is digital service tax. So digital service tax is something the OECD is currently working on under their Pillar 1 and Pillar 2 projects. Really, DST is how companies or how countries can tax multinationals who carry on digital transactions or whose business models are based on e-commerce. What OECD tries to do or is trying to do is to have a uniform approach so that almost all countries would apply the same laws. Otherwise, you have a situation where countries are taking unilateral steps. Unfortunately for OECD, it's not been able to issue the uniform rules. What it has done is have recommendations, but the rules are not yet been agreed, because we can understand why. There's pressure from America, which houses most of these big multinationals. There's also the problem of agreeing amongst over 100 countries what the rules should be. And of course, there was the delay in their debate as a result of the pandemic. So we've seen different countries no longer waiting for OECD to come out with this uniform approach. So we have unilateral measures everywhere. Last year, Nigeria introduced an SCP order which seeks to tax some of these e-commerce or digital transactions. We've seen the UK, we've seen Kenya, we've seen France also issue communication with respect to digital services tax. And the implication of this is that if countries throw out unilateral measures, there will be an increased risk of multiple and double taxation for these companies. Another thing we've seen or we anticipate is interplay with other treaties. We all know the AFCTA is in force, and we see potentials of companies that were not taxable in Nigeria becoming now taxable in Nigeria because of the trade across Africa. And this is vice versa because Nigerian companies will be exposed. So we see an interplay with these tax disputes arising from treaties or agreements like AFCTA. Finally, we now have common reporting standards in Nigeria and country by country reporting, where multinationals that have a threshold in revenue are expected to prepare a report that will capture their global transactions. Now, before now, you could have a multinational in Nigeria, and the multinational may have 50 companies globally or 100 operations globally. But because there's a Nigerian operation, FRS is only restricted, really, in many cases, to the Nigerian operations and has no global picture of what goes on around the world. In such instances, a dubious company can play around the rules to hide profits or shift profits here and there. But with the country by country reporting, companies that have global operations that meet the threshold are now required to prepare a report that shows their global profits, global revenues, global operations. And that can be exchanged either automatically or on request by tax authorities everywhere. So what are the challenges we see as a fallout? Mr. Ajibola spoke extensively on this, so I won't go into it. There's case law and there's statute that says tax disputes are not subject to arbitration in Nigeria. While I agree largely to some of these things, I think there should be, I think this rule should be restricted to domestic taxes, where the tax issue now becomes a cross-border nature, then I think it will be in place, or it will be fair to introduce arbitration to resolve such disputes. Now, people can argue, or commentators can argue, that having arbitration where the revenue of the government is at stake is an infraction on Nigeria's sovereignty. But here, that's what happens with treaties. Once a country decides to sign up to a treaty, it's argued that it loses some of its sovereignty because it's now bound by international standards, or it submits some of its sovereignty by virtue of that international agreement. And it's no different from taxation. So my view on this is where the tax becomes cross-border, because in these cases, Esso and Shell, the taxes were domestic tax related, it was PPT. But in this instance, if there's a cross-border element, then I see no reason why Nigeria should not be open to adopting arbitration, because you think you're protecting the revenue in one instance, in the other instance where you have to defend your revenue, then you lose out on arbitration. There's limited double tax treaty network. Nigeria has 19 double tax treaties. 14 have been ratified. One, we don't know, we're not sure, it's neither here nor there. Then the rest are in the process of being ratified, I believe. So we believe that the Nigeria double tax treaty network is too restrictive, and it's a challenge. We anticipate that the government would sign more treaties with other countries. Now, there's dispensation of the Federal Internal Revenue Service to advanced pricing agreements and even the DRP under the TIP regulations. So we've seen clearly where the FRS has said no, they will not engage in advanced pricing agreements. And this was some time back, about 5-7 years ago. We hope that the attitude will change, where you can guarantee taxpayers a level of certainty that would encourage them to carry on business in Nigeria. So that has to change. Then more skilled personnel. So in conclusion, what can we do better? Increase the tax treaty network, review our position on arbitration and APAs, continue to develop the right skill set at the national level and state level, and keep database of relevant information related to taxation. Thank you very much. I hope I stayed within the 10 minutes.
I don't think so, but that's okay.
Yeah. Okay, that's it for me. Thank you.
Thank you very much, Mr. Akinla. Mr. Ihebie, are you still with us?
Yeah, I'm here, sir.
Okay.
All right.
Let's hear from you then.
All right. My topic is actually handling the forced transfer pricing dispute before T8 in Nigeria.
Okay.
So I'm going to do a kind of the previous speakers have actually taken us around the world and everything. So about the topic of discussion. So mine is simply going to be a kind of practice oriented. Okay. I happen to have been privileged to handle the first transfer pricing disputes decided by the Nigerian Tax Appeal Tribunal. Yeah, we lost that case. I was not happy with the judgment, but what my focus here is just about because transfer pricing, like Akela has mentioned, is actually a very important aspect of cross-border transactions. So while thinking about the topic to write, and I said, well, why don't you just discuss this? Let's get the experience, look at the experience, because as we say, experience is the best teacher. So what are the lessons one can learn from there? And we can move on from there. Now, generally, I start by saying that when it comes to tax disputes, actually, generally, it has to do with issue of difference in interpretation of relevant tax laws. Now we know that under the law, no country is actually obligated to enforce the tax of another country, even despite the foreign agreements that we have. Now we are talking about the map. What happens in a situation where a foreign company come from a country that does not have a DTT with Nigeria? What happens in such a case? And that is what happened here. So the case under review is Prime Plastic against FIRS. And the facts are very simple, actually. Like I said, facts are usually never in dispute, or in tax cases. In tax, they're never the issue at all. It's about the interpretation of the law. And what happened there, in summary, is that the appellant submitted his transfer pricing documentation for 2013, 2014. And for the first 2013, they used what we call COP, that is CUP method. And for 2014, they used what we call TNNM. TNNM means transactional net margin, while CUP means comparable or controlled pricing method. In simple terms, transfer pricing just involves looking at a transaction between two related companies, two related entities, and ensuring that the terms they are pricing, the terms of that contract is the same as would have happened between two unrelated companies. For example, now, if I want to sell a car and I have two choices, either selling it to my wife or to Mrs. White, God knows that the price I will sell to my wife is different from what I will sell to Mrs. White. Don't ask me the reason, simply because it's my wife. I can give it for her free. Now, if
because I'm not your wife.
Of course. If I sell the car to Mrs. Goniko for 1 million naira, there will be tax on the 1 million naira, and government will receive more. But of course, if I want to sell that car, I will not sell it to 1 million naira to my wife. I may have to sell it like 10 naira. And so the tax will be lower. So what the transfer pricing rules requires is that I sell to my wife at the same price I would have sold to Mrs. White. Can you imagine that? I wonder how that will be possible. So that's what happened here. So they used CUP, like I said, because there was a related company, the parent company of the appellant was also selling the same product it was selling to the appellant to third parties in Nigeria. So they used the price of the third parties in Nigeria as their comparable to sell. While in 2014, the parent company didn't sell to any company in Nigeria, so they could not do that. They have to use, because there was no comparable, so they have to use what we call transactional net margin method, which means looking at the profit, which they expect the appellant to make the same profit in the transaction between it and the parent company, to the same profit that two unrelated company in two unrelated, that the transaction between two unrelated companies would have also yielded the same, the same range of profit. That is just what transactional net margin means. Now I was involved in because there was audit first. After audit, there were a lot of audit. The audit took, there were reconciliation meetings, which took close to a year. So during that time, it was recognized that yes, the COP that you used was okay, and the TNNM, the COP was fine for this particular type of transaction. The FRS agreed on that. And however, in reviewing in benchmarking or reviewing the transaction, FRS turned around and decided to use TNNM for the two, and for the 2013 and 2014, and that was actually contrary to paragraph 5.3 of the then transfer pricing regulation, even the current one, which says that when in determining whether there was, a transaction was at an arm's length, the FRS should use the same method that the company used in assessing itself. So in other words, what FRS ought to have used for at least 2013 was the COP that they used. So, and that caused issues. At the end of the day, FRS issued a additional assessment, and the parties had to go to court, had to go to TAT. And at the TAT, the appeal was dismissed. The appeal was dismissed. And I took a look at the judgments, and I have 3 points. The first is that the reason for the judgment, there were no reasons for the judgment in my own case. Please note that whatever I say here is my own personal opinion, and not really the firm I worked for. So I believe, having gone through their judgment, I believe that the reason there were no reasons apart from just a rehashing of the parties' argument. And I also believe that the judgment was not based on any provision of the relevant tax regulations. Like I said before, if the law says that for you to assess a taxpayer, you must use the same method. Now, if you use another method that was not used by the taxpayer, then you have run foul of that particular regulation. And we all know one thing about taxation, that taxation is strictly statutory. Okay, that taxation is strictly statutory. In other words, you must follow what the law says. You must agree with what the law says. So if the law stipulates that you should do a particular thing in a particular way and you decide to do it in another way, then that should not hold. Then also, I believe there was also a misunderstanding of the issues for determination. For example, one of the issues is whether decision review panel was actually set up, by the FIRS. And during the trial, we actually tried to elicit from the witness of the FIRS whether that particular decision review panel was set up, and we could not get any answer. Now, why do we argue that? Because I remember that if you look at the ISA SEC rules, there's a particular body that is similar to this decision review panel, and the SEC regulation actually provides for this particular body, provide for the setting or provide for the rules on how to approach this particular body. I think that body is called ADH. Everything is set out. But when we came with respect to the decision review panel for FIRS, there was no evidence of it being set up. There was no rules as to how, you are going to, a taxpayer who is aggrieved can approach this particular panel. So at the end of the day, the FIRS just informed the taxpayer that, look, we have referred to your case to the decision review panel, and this was done without telling the taxpayer, without informing the taxpayer about it, and that rule, the regulation states that it is actually the taxpayer. This was the old regulation. It has been amended now, but then it says that it is actually the taxpayer that can refer this dispute to the decision review panel and not the FIRS. So there is a kind of putting the cart before the horse in this case. So what are my experience about it? Like I said, there was the audit and the pre-assessment stage, and there were a lot of meetings. So how do you handle this as a consultant to a taxpayer or a legal practitioner to a taxpayer? The issue of transfer pricing has to do a lot with documentation. You have to, like someone said, documents don't lie. So you have to keep your documents ready. And believe you me, there is always a huge amount of documents involved. In fact, if I should measure the documents that we have to submit to the FIRS in terms of weight, they could actually get to the half of a pickup, because there were a lot of documents that were demanded, and we kept, the appellant kept providing all these things, And the second experience is that one has the engagement with the FIRS has to be constant, and there were a series of meetings, there were a series of presentations, there were a series of question and answers and what have you. Then you also, at the end of the day, when the assessment comes, you must object within time. Remember that despite the fact, I believe that despite the fact that we're talking about cross-border transaction, but truly, theoretically, the taxation of cross-border transactions may look international, but actually, in actual fact, they are local in nature, because at the end of the day, it is the law of the country that is concerned that may have to apply. Now, the trial stage, at the trial stage, you have to keep to the issues raised in the appeal. For us, they were, like I said, reviewing the 2 years with TNNM contrary to paragraph 5, subsection sub 3 of the transfer pricing regulation. Number 2 is we believe that there was no compliance with the provisions of transfer pricing regulation, no evidence of setting up the DRP, and irregular reference of to that particular panel. Then non-compliance with OEC regulation, and this is very interesting. Now, the OECD regulation provides with respect to TNNM that there's what we call profit level indicator, PLI. That is measuring how to determine the profit, the arm's length profit. And that particular provision says that in doing that, there's a formula, and that formula says that for the purpose of this particular transaction that was under review, that they should use, they provided different kinds of formulas, but for the purpose of this is what we call EBIT, that is net profit. But the FIRS in benchmarking the appellant used the gross profit margin for its GPM for reason best known to it. And this is contrary to what was provided in the OECD regulation. And lastly, irregular comparables. Now, the business of the appellant in this case was a bit unique. It was a bit unique, kind of, and that was even one of the reasons why it was difficult finding comparables. And during the trial, under cross-examination, we tried to find out from the FRS, what particular comparables did you use for this? Did you use anyone in Nigeria? They said no. Did you use anyone in Africa? No. Europe? No. North America? No. And everything. So, however, in their benchmarking report, they listed at about 123 companies that they used and everything. And the problem has to do with backing up this assertion with facts, with evidence that look, these are actually proper comparables to use. Then let's take a brief look at the DRP. Like I said before, the DRP is a very important panel. It's a very important body for dispute resolution, transfer pricing dispute resolution in Nigeria. And it consists of the transfer pricing department head, who heads the this panel. And the question is this proper? Does this not constitute the FRS being a judge in its own case? Then also there was a change that was made to that regulation in 2018. In 2012, the regulation grants the taxpayer the option of referring the dispute to the panel. But in 2018, it is the head of the panel that decides whether to refer the dispute to the panel or not. And I believe this limits access by the taxpayer. So I think the previous regulation is better. What are the lessons learned from my experience in this? The lessons I carry, even though, like I said, we lost that case, but of course, every event in life teaches us lessons. The first one is misunderstandings. We have to avoid misunderstanding because they can lead to terrible results. What was I saying? Why do I say this? Now, during the reconciliation meeting, there was a question that was asked. And what happened was that looking at the 2013 documentation where the appellant used CUP. And he thought it was 2014. And he was questioning one of the consultants to the appellant and asking him, okay, for this this year, you used the CUP. And the man, thinking that he was talking about 2014, said, no, we used TNNM. If we used CUP, it must have been a mistake. And that particular statement came back to haunt the appellant because the tribunal now held that, look, that they agreed that that the appellant agreed somehow, admitted somehow that using CUP for 2013 was a mistake. And that was not really what happened. So one has to be very careful in things like this. And I said the second lesson is providing all the requested documents. Providing all the requested documents may not be enough, actually. Your documentation must justify the pricing you adopted in the transaction. That is very, very key. You must be able to, kind of convince the FIRS through your documentation that the pricing is at arm's length. And lastly, do not be overconfident. Do not be too confident about it. And personally, this is personal to me because I actually believed that we were going to win this matter, but unfortunately, it was painful. Hearing and listening and hearing the tribunal say that your client is going to pay about 1.7 billion. It was a painful one. It was a wake up thing to me, and that is that. So, in conclusion, I must say thank you for listening to me.
Wow, thank you,
And
Mr.
I hope I
Ihebe.
kept to the time. Yeah.
I think you did better than the other two.
Wow.
But that's all well. That's all well.
Yeah.
Now, Mr. Igorikon White, maybe what we should do is, maybe I should pose some questions to you. I don't believe you have a presentation, right?
Well, I could do a recap of everything. It's possible for me to speak on that because I do have a few notes I could.
Okay, that's a recap of what they've already said.
Well, yes, and additional points to make.
Now, maybe if you have additional points to make, you can make those, because what I want to do was to ask you 1 or 2 questions on what has been presented.
That's fine. So maybe I could make these points and then you can ask the questions.
So make your points and let's.
Okay, thank you very much. So a lot of the speakers have spoken very well about the cross-border dispute resolution method for cross-border disputes. And I know that the pace of globalization has made cross-border tax disputes very inevitable. Now, the improper management of those disputes will result in multi-taxation, unfair tax practices that may hinder smooth operation of commercial activities generally and globally. Now, for that reason, the international community will continue to strive to develop adequate measures to prevent disputes and ensure effective resolution. One of the earliest measures, which I think has been touched on, is taken in negotiation of double taxation treaties, which has also been talked about, is the MAP procedure. Now, tax disputes in cross-border operations arise from questions of which jurisdiction has the authority to tax, just like I think Mr. Jimmy said, and what income or what profits. Now, for purpose of taxing international cross-border disputes, countries are divided into source and residence. So in summary, the source countries will have primary taxing rights over active incomes of businesses, while the resident countries would have primary taxing rights over passive income, such as dividends or royalties and interest. So that is just to add the point that has been made already. Besides the concept of permanent establishment. Okay, so ways of resolving tax disputes. Now, tax disputes are largely domestic in nature, although they sometimes arise from cross-border commercial transactions. Now, reason for that is not hard to discern. The power to tax is tied to territorial legitimacy and sovereignty. So countries all over the world will have bespoke domestic laws and procedure for resolution of their tax disputes. But regardless, tax disputes could be resolved internationally when they concern the application and interpretation of tax treaties. So in that context, mechanisms that have been put in place in these tax treaties to resolve international tax disputes are, more importantly, a lot of countries like Nigeria that have signed up to the OECD BEPS MLI. Now, cross-border tax disputes can be resolved through domestic dispute mechanism or special dispute resolution mechanisms in the DTT. The mechanism for resolving cross-border tax disputes in tax treaties and the MLI are the MAP and the arbitration or other forms of dispute resolution, as mentioned earlier. Now, for the MAP, it's a process by which tax authorities of two sovereign states negotiate to resolve the tax issues that have arisen from interpretation and application of the double taxation treaties. Essentially, it's government-to-government negotiation process of the tax dispute that has been referred, which can be triggered once the action or decision of one or both of the contracting states to a DTT will affect or result in taxation that is not in accordance with a DTT. So taking a cue from Nigeria's DTT with the UK, for instance, the initiation of MAP typically involves two-step procedure mainly. First is an aggrieved taxpayer who has issues with the application will lodge the complaint with the tax authority of the state of residence, and then the other state. Then the contracting state also considers the objections of the taxpayer and takes action. And if the second stage will take place exclusively between the competent authorities of the contracting state, where they are to endeavor to reach a mutual agreement. The MAP is an available remedy to and can be initiated by the taxpayers regardless of domestic remedies. Now, in a bid to ensure that there's effective dispute resolution, the OECD jointly launched the base and G20 jointly launched the BEPS Action 15 plans. One of the plan action, which is Action 14, was aimed at making dispute resolution mechanism more effective with specific focus in 4 key areas: preventing disputes, ensuring availability and access to MAP, resolution of MAP cases, and implementation of MAP agreements. And in the light of that, the MAP provisions in Article 25 of the OECD Model Tax Treaty, which formed the basis for the negotiation of over 2,000 bilateral tax treaties, was updated to ensure that agreements that are reached through MAP are implemented regardless of the time limits in the domestic laws of the contracting states. And then Article 21 also stipulates that access to MAP is available irrespective of the remedies provided by domestic law, meaning that taxpayers are allowed to initiate a MAP without first exhausting any available remedies. And many countries have permitted this in their practice. Talking about arbitration, which is to complement MAP and ensure timely resolution of MAP cases. The MLI also recommends the adoption of mandatory arbitration. Now, the issue with arbitration, as a lot of the speakers have mentioned, is whether different countries widely accept the arbitration mechanism under the MLA. There are different views on this. Some countries such as Australia, Canada, France, United Kingdom, and have expressed interest in adopting mandatory binding arbitration, but Nigeria refused to commit to adoption of the mandatory binding arbitration requirements of Action 14 due to its jurisdictional peculiarity. In Nigerian, tax disputes are not arbitrable. Now, arbitration, if adopted by the contracting state, would apply where the competent authorities are unable to reach an agreement to resolve the case pursuant to a provision of a DTT that provides that competent authorities of contracting states shall endeavor to resolve the case. Now, any unresolved issue from case between the competent authorities, if unresolved, will be in writing submitted to arbitration in the manner that is described in the MLA. Now, there are other different resolution methods apart from arbitration. Under the MLI, a contracting state could choose where both contracting states have made such a notification, have the controversy resolved by a different resolution. I think one of the previous speakers mentions APAs, mediation, and expert determination. Now, notwithstanding the requirement for a mandatory binding arbitration decisions shall not be binding on the contracting states to a DTT and shall not be binding to a DTT and shall not be implemented if the competent authorities of the contracting states agree on a different resolution of all unresolved issues within 3 calendar months after the arbitration has been delivered. So they have to choose whether they want to go by arbitration or they want to try other means. So it's not, you trying all of them at the same time. Dispute resolution under domestic law, basically, each countries have their own laws. And from the domestic law perspective, countries have their tax dispute resolution mechanisms, which are designed, to ensure effective and efficient resolution of tax disputes. The disputes mechanism and procedure bind foreign investors who have established local presence in the country. So in Nigeria, tax disputes are not arbitrable, as I mentioned. So resolving disputes of that nature are through administrative procedure and litigation. So the administrative procedure allows the taxpayer to object to the assessments or demand notices, and then the tax authority to allow or reject the objection before proceeding to institute an appeal at the TAT and upward. Now, if the taxpayer is aggrieved, then it can appeal. Now, advantages and disadvantages. I thought I should just mention that because quickly. Advantages of the MAP, a key advantage is it helps to attract foreign direct investments because of the confidence, in the procedure by foreign taxpayers. It provides taxpayers with alternative bilateral remedy to resolve their dispute. It's cost effective for taxpayers. The use of MAP obviates the need for legal representation and the associate costs. The flip side, however, is that the competent authorities may be reluctant to initiate MAP if it's going to involve significant costs to the government. This is often the case for developing countries. Now, it also fosters, cordiality and provides amicable means of resolving disputes between tax authorities without straining the relationship. So there's joint collaboration to resolve international tax disputes arising from the application of DTTs. Now, as such, MAP has the potential, as I've said, to foster that cordiality. And it also ensures in the interpretation and application of DTTs with the consequential positive effect on commercial transactions. So there's consistency in the interpretation as opposed to going to different local domestic courts to give a decision on the issues arising under a DTT. It takes care of the lack of specialization of domestic court tribunal members and judges, especially on technical issues. Emeka took us through his pains and trials, in respect of his case, and a lot of what comes out of there would be lack of specialization amongst the FIRS officials, and even at sometimes at the tribunal level. A lot of what we see is that there is a lacking of specialization, which needs to be built, on that issue. So that, of course, doesn't come up when you, initiate the MAP process, and it's not cumbersome or uncertain as domestic tax litigation would be. There is also timing advantage. Taxpayers need not wait until tax is assessed or charged to initiate the MAP. Once they have a threatened action, they could initiate the MAP. And the duration of the MAP is comparatively shorter when you have to compare it with the timeline for domestic resolution, starting from TAT all the way to the Supreme Court. The disadvantages are there, which is that MAP's resolution have no precedential value. It's not a precedent, and it may be disregarded by domestic courts in very similar cases. The resolution, although the resolution represents an objective evidence of the mutual understanding of the competent authorities. Now, tax authorities are not required to compulsorily initiate MAP to resolve those tax disputes. These result in long delays in resolving such disputes. So you'll see that, especially in the guidelines, they may just decide for whatever, although the guideline says is if you don't provide enough supporting documents or you fail to provide answers to issues that have been raised, they may decide not to, raise that, initiate it. MAP as a dispute resolution mechanism also takes place between the tax authorities of two sovereign states, contracting states with little or no taxpayer involvement. And there are no uniform set of rules or process which guides the use of MAP. So those are the disadvantages to that. For arbitration, disputing parties will get the opportunity of having their tax disputes, which are mostly technical, resolved by experts, and is generally considered faster. And parties have some form of flexibility regarding procedure, such as choice of venue, arbitrators, and whatever. Typically, parties have a choice in respect of the conduct of their proceedings in arbitration. It helps to also provide finality to the case referred to the competent authorities where they are unable to reach a mutual agreement. So it's not a case of, okay, the competent authorities are unable to agree and that's the end of it. So that's one advantage of arbitration. But the disadvantage is costly, it might be costly. It may not be as cost effective. Then it also has no precedential value. And the court still has to be consulted to enforce these awards that have been handed down, and they are not binding actually on the courts. For the this litigation process itself, I think litigation also has its advantages and advantages. For advantages, it sets precedents and clarifies the law. There is certainty of outcome or a decision, unlike MAP between the contracting parties, competent authorities. And then there's a formal legal process for conduct of a dispute. It's also is the most effective alternative if sanctions or penalties have been imposed on a taxpayer. So you want to quickly go to court to get an injunction or where they have already sanctioned you or there's a penalty. That's the most effective. And then lack of specialization or experience of administrative tribunals on the technical issues involved. Well, that's a disadvantage actually. It's one of other disadvantages that there's reputational risk for taxpayer companies. It's also characterized by delays, the time limit within to finally get to the Supreme Court and get a judgment can take more than 10 years sometimes. Then there's the possibility of appeals, which also again elongates the period, and then it lacks confidentiality. So it's essentially state controlled. So those are the advantages and disadvantages. And quickly to round up, the context, talking about the interrelationship between the different means of the dispute resolution. The point to note is that there's coexistence of all of them, both local and cross-border. So most MAP provisions in DTT stipulates that access to MAP is available irrespective of the remedies provided by domestic law. So in essence, taxpayers can initiate a MAP without first exhausting any available domestic remedy. While some are made as prerequisite to others exist on parallel tracks. And then the OECD guidance also urges the adoption of flexible and transparent procedures to coordinate the procedures where they are not permitted to run on parallel tracks. So contracting states are often required at a minimum to put in place procedures on how to deal with cases where MAP and domestic procedures have been invoked simultaneously. Now, first, of course, release these guidelines, and under those guidelines, presenting a case, the competent authority to initiate MAP does not deprive a taxpayer from the domestic law remedies, but the CA will require that the taxpayer suspends the domestic remedy if a MAP request is accepted. Now, if the taxpayer is not satisfied with the MAP ruling, then the taxpayer may seek a legal remedy. A note of warning, it's often advised that the taxpayer commences, puts in an objection and commences an appeal in accordance with the provisions of the law and then may suspend that if a MAP request is accepted, especially because under the guidelines, your collection of taxes will still take place. You'll still be required to make taxes. So the only way to suspend that provision is if you have a valid appeal in place to ensure that your rights are protected. Now, the administrative panel, where the administrative panel, that's the TAT, has taken a decision, it does not hinder the taxpayer from pursuing its MAP. So if a court decision on a tax dispute, the decision is final and it is binding. And I think, so that's, I think, wraps up the points I'd like to make. Yeah.
Okay, thank you very much. That was very interesting and illuminating. Now, I notice I don't see that there's anybody asking any question in the Q&A. There was one question which I think Fulajimi has answered. So I will, take up the questioning. Starting with the first presentation, there are a few points that Mr. Ajibola made about appropriate zone, and TAT jurisdiction, which I agree with. There was you referred to some TAT rulings on the appropriate zone, but there was actually a federal court ruling as well on that. I don't know if that was one of the things you mentioned, because in one matter that I'm aware of, the TAT had refused to transfer an appeal to the appropriate zone, and so the taxpayer had to appeal to the Federal High Court to get the order of transfer.
Wow.
Oh yes, this was in the early days. It was in the Abuja zone. We had a matter that involved a Lagos-based, taxpayer, and we asked Abuja to transfer. They said no. Now the thing is, you need to remember the context. At that time, they had just set up TAT with 8 zones, and they felt that they needed to keep each zone busy, because the truth of the matter was that the majority of cases were in the Lagos zone. And so you had Maiduguri zone, I can't remember what it was called, that would be Northeast zone, probably had little or no cases. So there's an oil company who had a matter transferred to that zone, and they said, look, what are we going to go, even to get to that place, you can't just fly there, you need to fly and then go by road. They said, please transfer it. So this was Abuja zone, and we said, look, but the taxpayer is in Lagos, FIRs that's audited is in Lagos, everybody's in Lagos, the paperwork is in Lagos. Why should we come to Abuja? Doesn't make sense. TAT Abuja said no. The Federal Court Abuja agreed, and it was transferred. So there was that. With regard to TAT jurisdiction, yes. Now it's been controversial. It still is. Federal Court, gave conflicting decisions. The Court of Appeal has ruled in favor of the TAT's jurisdiction, but the party that lost, in which case I think that was NNPC, is appealing to the Supreme Court. So it is still possible that the Supreme Court will decide.
Out.
Sorry?
I said the jury is out.
Exactly. The Supreme Court may decide that they agree that the TAT has no jurisdiction. So don't keep tuned to this channel.
Don't sit too comfortably. Thanks for the heads up, Mr. Emua. And on the TAT.
Yes.
Yeah, I said on the TAT, Mr. Hembe, I don't think you're a lawyer, because it was interesting just to listen to his experience and his comments on the case that he went through. And I think he went full circle, because at the end of his presentation, he, I think, might have answered his questions. So when he talked about the fact that maybe there was no reasoning in that case, and I think it was given by a Lagos State, a panel sitting in Lagos State, not in the Southwest.
Yes.
He also said, well, we provided so much documentation that it would have failed a pickup truck. And it's noteworthy that from a lawyer to a non-lawyer, that volumetric weight does not translate to probative weight in terms of evidence. And I beg your pardon. Then I apologize. I apologize for that statement. But so I'm stating the obvious. And TAT tries issues of fact essentially. Facts must be pleaded, must be supported with evidence, and they must be corroborated. So at the end of the day, whatever it may be that the outcome was, you yourself, you said, not to be overconfident and to make sure that every single document that you need is put forward, because you may find yourself making assumptions that are not shared. But it was interesting that you shared your experience.
But interestingly, Emeka also made an admission against his own interest when he says he says there was an instance where during the audits, where FRS asked a question and then the consultant answered in a way that was later on, in fact, in your words, Emeka, it came to haunt you.
They used the wrong. they used the wrong process for the transfer pricing.
So, I mean, I feel your pain, but when you say the tribunal had no reasons, that's a valid reason.
Absolutely. But don't worry, you can appeal. And while Mr. Emoa's point remains hanging over the work of the TAT, the fact is that you have a right of appeal to the Federal High Court. So at least carry on with that one for the time being.
Oh yes, of course. We're all appealing various matters regardless.
I'm telling you.
And we're praying that the Supreme Court does not disrupt this last 10 years.
That's
the flow.
But on matters of policy,
work.
on matters of policy,
Yes.
I mean, we can't say what the Supreme Court will do, but the matters of policy, and we look at Section 251B, that calls that specifically refers to a court, and there are decisions that says the TAT is not a court. I struggle to think that the Supreme Court will throw away everything the TAT has done.
Okay, I'll give you one very good point that they can use if they want to, if they're minded to go that way. From the TAT to the federal court, you can only appeal on matters of law.
But there's also a provision, Mr. Moore, there's also a provision that says when you get to the federal high court, your cases is heard by way of a rehearing.
Yeah, you could do that. It's a choice, actually.
So I mean, I know where you're coming from because I've held on to those arguments before.
But that's where the problem is. So if the Supreme Court says, well, this provision makes it look like the TAT is taking over the power of the federal court, and you can only appeal on a matter point of law, then they're saying that on that basis, Section 251 is breached. So
that's a valid point, sir.
If they're minded to go that way, they can use that as the basis. That's what I'm making. So it depends.
I have a question.
I was just going to add on that point before we move on. I think because in one of those cases we're also handling, we asked the court to look at the TAT as an administrative tribunal, really. It's not and then one of the laws, administrative law, is also for a taxpayer to exhaust, all the remedies that he has before he approaches the court. Yes, so it's one of the bases for which we argue that the TAT jurisdiction doesn't in any way infringe on Section 251. But I agree with the point that provision that sort of limits the the issues that you could appeal on to points of law, sort of as if constricts, the powers of the Federal High Court, and that could really be the sub point that the court will have to consider to say, oh, you can overlook it, you can, because really and truly in appeals that we've done, we go on the basis of law, but we still bring the facts to support the law. So yeah.
Yeah, well, when you say you bring the facts, do you lead evidence afresh?
No. So that's the thing, and it's even in an appeal setting. So you really don't have the basis of leading evidence. So it's really based on the records.
Yeah. So when you talk about a rehearing, it's not really a rehearing in that sense. And that's why I say the Supreme Court, if they are minded, can use that as the basis. And you can't blame them. You can't fault them if they use that. You see.
Or in the alternative, Mr. Emua, they may find that just that provision offends the Constitution,
exactly,
and then say that, well, it's not only on matters of law, but you can appeal on matters of fact, and that would not then stop the jurisdiction of the TAT, but just mean that you can appeal on matters of fact.
But how would that work? Because if you've already gone to the TAT and you have a decision from the TAT, then you say you want to go to the Federal High Court and start all over again.
A rehearing, as Mr. Killa said, a rehearing, effectively.
I see.
Yeah, so you can, and when you say a rehearing, in my own view, it can either be you lead evidence again or you argue. So there's no restriction to the definition I'll give a rehearing. More so, the Federal High Court has powers, it has appellate jurisdiction. So I never took jurisdiction from you as a tax appeal tribunal.
Absolutely.
I just say, you can come to me, I can rehear your case. I have appellate jurisdiction, and I have original jurisdiction. So I think really the discretion is at the level of the Federal High Court to say, okay, I'll carry out a rehearing and I'll hear facts, or I'll hear your case on matters of law only. I think the ultimate decision is for the Federal High Court to make. It can donate, it can decide to say, I will not exercise my original jurisdiction in this case, or to say, yes, I will exercise my appellate jurisdiction in this case.
Well, I agree with you, but the truth of the matter is that in the Federal High Court, they have, you may say they have done it, unknowingly, they have chosen not to review facts in most of the matters we've been
in previous decisions.
Yes.
You are right.
Exactly.
And actually, with respect to that particular provision, in my opinion, the issue of appealing on basis of law alone looks more sensible to me because of the fact that, like I said earlier, tax disputes are usually on matter of law, interpretation of statutes. You hardly have issue of facts or people contending. I mean, the assessment will always be the assessment because it's always, most of the time, it's always documentary anyway. So most of the time, everything is written down. So,
but when you go to transfer pricing disputes, I mean, you've done a transfer pricing case, so you know those cases are highly fact specific. So you will need a lot of facts for transfer pricing, for example.
Really?
I hear you. Yeah. So if you look at the big transfer pricing case globally, it's a question where you call economists, you call people in the business.
Correct.
So you call people in the factories. I mean, it's highly factual. So to a large extent, domestically, yes, we can say it's a construction of the law. But there are specific cases, and the TP is big ticket for the government, where it's purely, or it could be decided purely based on facts.
Yeah.
So the problem now is the Federal High Court really skilled to take, on those kind of factual hearings?
Well, they may not be skilled, but we're talking about even the issue of jurisdiction. So we agree that this issue of jurisdiction is can go either way,
And then when we cross that bridge, we ask the next question.
So ASQ, you have a potential topic for another reconstitution of this panel when the Supreme Court
for a rehearing.
Absolutely.
So please, I have a little question, please.
Yes, go on.
And my question is this: what is the actual legal status of this of the DTAs and the maps that we have today, in the light of Section 12 of the Constitution?
Okay, now that's an interesting question, which my view though is that people sometimes mix up agreements. It's not every agreement that the government enters into that is a treaty.
The treaty, correct.
And that's where the problem is. For example, I'll give you a good example. You have something called bilateral services agreements. You know what those are? So
I've heard of them before.
Yeah, Nigeria will agree with the UK that we'll have 20 flights from UK to Nigeria, and we'll have 20 flights from Nigeria to the UK. So they'll reach that agreement. Then each country will now nominate who will fly those 20 flights.
Out.
Yes, British Airways, Virgin, whoever. That is a commercial agreement.
Okay.
But it's not a treaty. Now I think the test that probably should be applied is, does this agreement lead to any departure from local legislation? So if in that bilateral services agreement, there's a provision in Nigerian law which is being departed from, then you may have to have some legislation to back up that element.
Right.
But quite often, there's nothing like that. So the BASA says you can do 20 flights and I can do 20 flights. The BASA also says that British Airways can open a branch in Nigeria. So the British Airways office in Nigeria is not a separate corporation.
Mm-hmm.
CAMA says you can only have a separate company if government permits, right?
Yes.
Aha. So BASA also allows BA to have this office here without setting up a new entity. Same thing with KLM, same thing with Virgin. So again, it's not a departure from local law. Do you see the point? Aha. Yeah. Now, when you go to DTAs, CETA and PPT and all of them have provisions in the legislation saying if the government wants to enter into such an agreement, they can.
They can.
Now, to what extent have they departed from local legislation? If you look at local legislation, it quite often provides that CETA, for example, says the presidents, although they've added National Assembly now, can give you a waiver or exemption from any of these provisions, right?
Yes, yes.
So if he signs a DTA, he has exercised the powers that are inherent in the CETA. You see? So that is one view, but nobody is analyzing it. We're getting to the point where they're saying, no, it must come to National Assembly, which, okay, that's fine. If they feel that, okay, it requires, especially from the other party, they too feel that, look, we don't want a situation where somebody challenges it. So please let your National Assembly look at it so we know that we're all Yes, so that's so for everybody's comfort, you do that. But it's an issue that really is worth looking at. Now, in some countries, every government agreement has to go back to the local legislature. In Ghana, no matter the type of agreement it is, Parliament in Ghana must look at it. That's their own constitution. So you see, it depends on your, so exactly. In other words, they don't have what we have, where you can have a statutory instrument that a minister is empowered to sign or introduce, that doesn't go back to legislature. In Ghana, they don't have that. Every so-called statutory instrument or subsidiary legislation must go back to Parliament. Even these agreements, like BASA and what have you, must go to. So Parliament controls. So the executive can't go on their own and sign away whatever. Parliament needs to know about it. That is their system. So you have to look at each system has its own peculiarities. Anyway, I have one or two interesting questions. We talk about arbitration and tax disputes not being arbitrable, but when we are talking about arbitration in the context of a double taxation agreement, is it really the tax liability that is being determined in arbitration, or is it the intention behind the intendment of the DTA that is being determined? In other words, the two governments who signed this DTA are trying to decide, okay, what did we mean by this provision, this Article 8, 9, or 10, or what have you? Once they decide what they intended by that provision, they will then ensure that the appropriate tax authority applies the local legislation in accordance with the DTA. So even though you say tax disputes are not arbitrable, in this case, is it really a tax dispute that's being determined in arbitration, or is it the agreement, the DTA, the agreement of the two countries that is being determined?
It's a very good point, because indeed, yes, what happens after the process is that the taxpayer has the opportunity to if it's a self-assessment, represent their position, or the tax authority or relevant tax authority in the state has the opportunity to issue a new assessment. So the assessment is not the issue being determined during the process. It's actually just the interpretation of the statute, and the reassessment is a consequence of whatever is decided at that point. So I actually agree to your point that it's not the tax itself that is being determined.
Yeah.
So I think
but the thing is,
fine point.
Okay.
Sorry. Okay. So there's a fine point there to make, because it's what is exactly the interpretation of a tax dispute. So I agree with the later points made that yes, it has to do with the interpretation of the DTT, but essentially it is all about whether a taxpayer, should be taxed, the income of a taxpayer should be taxed in one way or the other. So it may still narrow down to what exactly is a tax dispute, in as much as we're talking about the interpretation of the DTT. So there's that fine point, and you would always, this is part of what has really caused a lot of issues, even in those cases where the Federal High Court has said the tax disputes are not arbitrable. They were clearly contractual issues, but because it raises questions and issues of controversy that relate to something to do with, obligations, or taxing obligations,
Yes, but in those cases, they're looking at disputes between the tax authority and the taxpayer.
Which cases are you referring to?
No.
Sorry, is it the cases in court?
The ESO case, SNEPCO cases.
For the ESO cases, actually, the court it was actually a contractual dispute between the two parties, but the court says because you're looking at your tax obligations under that contract, it is a tax dispute.
Yes,
that's exactly what they said.
Yes, that's a dispute with the tax authority in country. So the issue wasn't whether the tax authority, you are subject to that tax authority or not. Now, if ESO had an MAP as well, I'm not sure that the court would have been able to say that, no, that MAP cannot proceed, because it would have been an MAP between the two governments. It would not even involve ESO.
There would not be parties.
Yes, exactly.
But there are a couple of points to raise. So I know we usually say 2 points. The first is that I don't think taxpayers are exclusively shut out of double tax treaties, of MEP procedures, because if you read the commentary, it says a taxpayer shall have a right to present its case and a right to legal representation. So what that means, we don't know. It could be you write something and you submit it, or you actually make presentations. So I've been in meetings with FIRS where the question comes up as to, would a taxpayer have the right to make his case? And yes, in instances, you make your case, but then you excuse yourself for the authorities to debate or to speak. So taxpayers have a big role to play in that process.
Yeah,
and to the first point, sorry, before, when you say it's a question of interpreting the DTTs or DTAs, but don't forget that when you interpret them, they have tax implications.
Correct.
Now, if we take a classic example of a double taxation in on a taxpayer or a business, don't forget that the double tax treaty also makes provisions for corresponding adjustments. So if we interpret the law either here or there, there's an implication tax-wise for one government. A government that has issued an assessment, because a case is against it or a decision against it, it still has to make a corresponding adjustment, which would mean giving up some taxes.
Yeah.
So we cannot conclusively conclude, if I may use those words, that an MAP process or arbitration process merely interprets the tax treaty, because invariably there will be tax implications for both countries.
Yeah.
One country will get more, and one will get more.
I agree with you. What I'm saying is that at the end of the day, what is happening is the two countries are trying to agree about what they meant by this DTA. So if they agree, once they agree that, look, when we wrote this sentence, this is what we meant, they then apply that to the taxpayer involved. You see,
it's a two-step process.
Right, exactly.
What is binding on them is the interpretation that they've agreed upon. If after that interpretation, one party refuses to raise an assessment, that's a separate matter.
Yes.
You understand?
What if as a result of that resolution, a party who believed that he wasn't supposed to pay tax now has to start paying tax, or a party
so that's exactly the point I think Fola Jimmy made, which is what I'm trying to also emphasize, that it will still come down to whether there is tax issues involved, and
I agree
on
that
its own will be the next question, whether or not it should be arbitrary.
But if a taxpayer ends up having to pay tax which he thought he shouldn't pay, then he has no choice, because the DTA was not entered into by him. The governments entered into the DTA between themselves in order to help the various taxpayers. If they say to the taxpayer, look, when we signed this is what we meant by that sentence, what choice does he have?
It was always law.
Yeah. If the two governments say, look, when we signed the agreement, this is what we meant, so you go and pay according to that agreement, what can he say? He cannot say that, no.
If I were the taxpayer, I will say that thing is not binding anyway. I will please section 12.
Yes, so you will then depend on domestic tax law. Yeah. And that may not help you, because that's why you went to MAP in the first place.
Exactly.
But I understand where you're coming from now, sir. I think you're coming from your statement was in response to the fact that we say double tax or our tax matters arbitrable. And your response is, well, we're not looking at tax per se. We're looking at the interpretation of this. And I think, again, that's where Mr. Adikole is coming from. Even the SNEPCO and ESO cases, the court at the point recognize that even the parties agreed that, okay, this is not a tax dispute. This is purely contractual. However, there are tax implications falling out. If we decide this case either way, there will be a tax implication too.
Yes, but what did the court say? The court said that what the party should have done was to refer it to a domestic tax court. That's what they were saying. They didn't say go to MAP. That's why I say if MAP had come in, the courts could not have stopped that MAP.
I guess to answer to respond, I guess the strategy should have been to sever the issues.
That is the point the parties tried to do. But let's be honest. Let's be honest. The context, the bigger context is the point issue here. Government didn't want this money escaping. So it got the federal court to make the order stopping. There were 3 arbitrations involved, not just ESO. ESO was one of the 3. So it stopped all 3. It didn't care whether, he says it's not a tax issue. It said, no. We can see that there's money involved and, you are deciding. because the reason why the party said it was contractual is a bit like that case in the case of withholding tax, Adebi and FRS, what was it called now? Akiyemi, where the parties agreed.
What came to my mind? Akinpelu and Total.
Akinpelu and Total.
Yes.
Yes, the parties agreed that the withholding tax in the transaction should be borne by one side, regardless of what the taxman says. And when it went to court, the court said, well, yeah, all you're doing is deciding who will bear the liability, who will bear the burden. You're not trying to determine that there'll be no liability.
Yes.
So in this case,
or that the rates anyway.
Exactly. So in the case of these oil companies, all they were doing was saying, this is how who will bear the liability, or the actual liability will be determined by FRS. We're not removing that from FRS. But between us as contracting parties, if the money is 20 naira, you will pay 19 naira, I'll pay 1 naira only. That was what they were trying to agree between themselves. And the court says, no, this is a tax matter. And that's why I say the bigger context was the issue, because the counterparty was a government party. So if NNPC collects the money as dividend, it goes to the same government. If FRS collects it as tax, it goes to the same government. So really, they had nothing to lose. Either way.
I hope that when we call you to speak as an expert, you'll be willing in some of all these cases, Mr. Edoma.
Well, you have to pay me well. This one, I've given Esquire, I've given Esquire free time. This one, you will not be free also.
You might be disqualified actually, because your firm also is engaged in one of all these cases.
We'll discuss that later. Don't worry, we can find a way. Don't worry about qualification and conflict.
I think, yes, I agree with this. But I think just like you said, it was just that principle of protectionism, protecting the money belonging to the government.
And let's be honest.
Want it to go. Yeah, because even the section 251, if you really do interpret that provision, nothing in there says that you cannot, resolve the issues by arbitration. It only says if it is the dispute is between courts, then it is this court. But when you decide on your own to decide contractual obligations, whether it implicates taxes or not, it's your business.
But let's be honest. This is nothing peculiar to Nigeria.
Exactly.
Every country is jealous of its tax revenue.
Tax base,
of course, sovereignty.
It's tax revenue. Now, America introduced FATCA. Do you know the history behind it? The Swiss banks used to have so-called secret accounts. It's not only Nigerians who were using it too. So Americans had monies in Swiss banks, which were in secret accounts, and the taxman in America did not know about the money. But they knew that money was there. So the American government asked these banks for this information. The bank said, no, we can't give you the information. We have secrecy, blah, 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 blah. The American government put pressure. They bullied the Swiss government. And look, tell your banks to give us this data. Otherwise, we're going to have a fight here. Eventually, the Swiss government had to prevail on the banks in the Switzerland to provide the data. So American government then had this information, so they could call the taxpayer in America and say, Mr. Man, you have $5 million over there. You didn't report it. What happened? Please give us our tax. So that is where FATCA came from. Of course, once the Swiss banks started giving to America, every other country said, where's our own? So they now give to everybody. So in fact, if you have money there, don't be surprised when the Swiss bank writes to LRS.
When I have money there, right?
Have they written to you, Mr. Moa? Have they written to you?
Good question. Very good question.
All my money is in Naira here. Then another point to remember is there was a worker in one of the banks in Switzerland who stole information from his bank. He sold this data to the British government and they bought it. And they then used it to tax British citizens. Do you understand? Yes. So they didn't care. It was stolen information.
It matters not how you get it.
Exactly. They paid for it knowing this chap had stolen it from his bank. But it didn't matter. They took that data and started assessing the various taxpayers that you have 10 million pounds in this place. You didn't ever reported it. Where's our tax? Same thing. I think one of France or Germany also paid for the same data. Yeah. So every government is jealous of their revenue, their tax revenue. So don't blame FRS and Nigerian government. It's done everywhere. They know it was stolen data. They paid for it, and they used it.
It's no longer privileged or confidential.
Yeah. Anyway, so
on that note,
thank you all. Thank you all. I think we've had a very interesting conversation. Let me leave it to Tosin to close the session.
you are muted.
So this question, Mr. Imuwa, I know we've overshot our time, but
okay, was there a question? I didn't see it.
Yeah, the question there. Hello, Mr. Imuwa. Please, can you explain again the difference between treaties and other commercial agreements, bilateral, such as BASA, determine one is a treaty or commercial agreement? Thank you.
Okay, well, I'm only expressing my view, which, if you go to court, you may find that the court don't agree. But I'm saying that if the agreement does not depart from local legislation, then it shouldn't be, it shouldn't require, going to national
ratification.
Exactly.
Or domestication.
And there are many agreements that governments enter into. That's the truth of the matter. We don't realize it. There are many such agreements. The BASA that Nigeria has is with several countries. There's a BASA with the UK, BASA with France, with Germany, with the US, with every country, and it's just a commercial agreement. So long as it doesn't touch on local legislation, there's no issue. So there are many such agreements. So I don't know if that answers the question, but you need to look at the agreement, see whether there's any departure from local legislation.
Thank you so much. Thank you. Okay, so I must say a very big thank you to everyone who has been on the panel today. Thank you to our chair and moderator, Mr. Imuwa. Thank you, Mr. Ajibola. Thank you, Mr. Akina. Thank you, Mrs. White Ademola. Thank you, Mr. Aide. We've really had a very robust and insightful session today. It's been very rich, and I'm sure all our participants will agree that it's been a very good one. And we really appreciate you. We thank you for taking out precious time from your busy schedules to sit at this panel, even to prepare for the webinar. We want to say a very big thank you. Thank you so much. And we also want to say a very big thank you to our sponsors, G. Elias & Co. and Advocate Law Practice. They are our sponsors, and they are the reason why today's webinar has been made possible. And to all our participants, we want to say thank you for being a good audience. Thank you for listening in today. Please note that our next webinar series, which is titled Flying Solo, Is This the New Normal? Managing Your Practice, Team, and Finances, will be coming up on Friday, the 29th of January, 2021, and it's going to be coming up at 11 a.m. It promised to be very insightful, and so we look forward to engaging you all there. And also, like I mentioned, that registration is ongoing for our 12-week virtual distance learning course on power. It's titled The Dynamics of Power Contracts, Regulation, Contract Negotiation, Documentation, Project Financing. It's a 12-week virtual distance learning course, and it's going to commence on the 16th of February 2021. So if you need more information about any of our trainings or webinars, you can send a mail to o.cholanke at esq-law.com. So thank you all so much, and have a wonderful day ahead.
Thank you for having us. Yeah, thanks everyone.
Thank you. Thank you, everyone.
Thank you so much.
Bye-bye.
Thank you.
Bye.
Bye.
Thank you.